Okay, so now let's move on to your next topic, that is essential elements of a valid contract. You will here know what are the essential elements, what are the important elements that form a valid contract. This topic you'll be studying in a depth. It's a very important topic. So according to section 10, it says that all the you studied about agreements, right? You studied about what and how you form an agreement, how that particular agreement turns into contract. So here it says, according to section 10, it says all the agreements are contracts. Now when will all the agreements be contracts? Only if they are made by free consent of the parties. There'll be always two parties in an agreement, or three parties, or multiple parties, right? I think you are all business students, you're all commerce students, you'll know what is business and how the parties are formed. So all the agreements are contracts if those agreements are made in free consent of the parties competent to the contract, who are competent to the contract. Okay, these parties will be competent to the contract for lawful consideration. What is consideration? Consideration is nothing but the amount of money. It is some amount of money which they will enter into an agreement or a contract for. Okay, and with lawful object, they will have certain motive to achieve, and they will have certain rules and regulations, and are not hereby expressly declared to be void. Okay, these elements or objects will not be expressly declared to be void. What is void? Void is something which is not binding. Okay, all the rules and regulations will be as per the rules and regulations which are set as per the Contract Act, and you should make sure that you should not have a very negative motive. Okay, suppose there'll be certain people who will enter into business to make black money or something like that. You should not have such motive in a business. When you have such motive in a business, your agreement will get cancelled. Okay, your contract will get cancelled. Whatever agreement you have, whatever contract you're entering into, it should be according to the rules and regulation, and it should be with a good motive. It should be that particular business should benefit you as well, and as well it should benefit the society also at large. Okay, so this, it says all agreements are contracts only if they are made in free consent of the parties. You should take the consent of all the parties, whether they are actually okay with the terms and condition, if they are okay with the amount of money which is being set as a consideration, and with a lawful object. Okay, you should have a very good objective for the particular contract. Only then it will form a valid contract. Okay, and it should not have any element. Okay, it should not have anything because of which it will be declared to be a void. So now the following essential elements must coexist. The essential elements must coexist to make a valid contract. Now you will see certain elements which need to exist before to make a valid contract. Only if these elements are there, it will become a valid contract. Okay, now these are the 8 elements. Now only with these 8 elements, only if you have these 8 elements with you, then only you will be able to form a valid contract. Okay, so the first one is intention to create a legal relationship. You are with an intention to create a legal relationship. Firstly is your intention to what? To create a legal relationship. Legal relationship, it could be with 2 parties or 3 parties. Okay, 3 parties or multiple parties. Okay, now here the parties ought to have the intention to create a legal obligation between them through the form of offer and acceptance. Okay, one party will come and propose, the other party will accept it. When you propose and when it is accepted, you will form an agreement, right? Only when the accepted agreement or accepted proposal is added with a certain rules and regulations, only then it will turn into a contract. Okay, so here they should enter into an agreement with an intention to create a legal relationship, these parties in an agreement. Okay, now they should have an intention to impose duty on the promisor. Promisor is who? The person who is promising to fulfill all the duties and responsibilities. Okay, now they should have an intention to impose duty on the promisor to fulfill the promise and bestow a right on promise to claim its fulfillment. Okay, it must not be merely a moral one but it must be a legal one. Okay, now one person will take will take the responsibility of fulfilling that particular agreement. He will become the promiser. Okay, now the promiser should not only take it with an intention of, okay fine, I will do it. No, it should not only be with a moral one. Okay, he should take it in terms of on legal basis. He should be able to, when he's taken something with such an intention, he should be able to fulfill that particular thing. If such intention on the parties is lacking at the time of making the contract, there will be no valid contract. Okay, if you do not form the contract with terms of creating legal relationship or with the intention of fulfilling that particular agreement, then you will not be able to form a valid contract. Only if you have good intention of making it legal, only if you have intention of completing or fulfilling all your promises or creating legal relationship, only then you will be able to form a valid contract. For example, a husband agreed to pay his wife certain amount. Okay, he's agreed to pay his wife certain amount as maintenance every month while he is abroad. Okay, he's agreeing to pay certain amount of money for her maintenance every month until when he is in abroad. But the husband failed to pay the promised amount. He promised to pay certain amount, but he failed to pay the amount. He did not give the amount. So wife sued him for the recovery of the amount. She went to the court of law. She sued him saying that he hasn't paid the amount that he promised. Okay, here in this case, wife could not recover as it was social agreement. Okay, and the parties did not intend to create any legal relation. See, creating legal relations is very important, but here the wife was not able to sue and catch him as per the rules and regulations. Why? Because it was a social agreement. There was no legal agreement which was formed. He just told that he's going to pay certain amount of money until he is abroad, but he failed to pay. So the wife tried to sue him, but it was not taken into consideration because it was a social agreement. They did not intend to create any legal agreement. There were no rules and regulations that if you do not pay certain amount that I will sue you as per court of law. No rules and regulations or no legal terms and conditions were there. So that is the reason she could not sue him under the court of law. Okay, I hope it's very clear. It is this example is as per Balfour versus Balfour. Okay, this is very important. When you write the example of Balfour versus Balfour, and please write down this example while you're writing in an exam. Next element is lawful consideration and lawful object. First one is you need to have an intention to create legal relationship, right? Second one is you need to have lawful consideration as well as a lawful object. Object is nothing, an objective. Now, to make it a valid contract, why is this element very important? Because it is a very essential element of a valid contract. It is important to form a valid contract. This element plays a very important role in forming a valid contract. Because consideration, what is consideration? Consideration, as I told you all, it is an amount of money or a sum of money. Okay, consideration is a technical word meaning thereby quid pro. Okay, it's technical word meaning quid pro quo. Okay, that is something in return. Consideration, technical word meaning is quid pro quo, that is something in return. You are getting something in return. Okay, when you're entering into a contract, you are obviously generating certain amount of profit or certain amount of money. That is, you are getting certain amount of something you are getting in return. Now, it must result in benefit to one party and detriment to the other party, or detriment to both. Okay, it should result to profit to one party or detriment to other, or it should result to detriment to both the parties. Okay, for example, you can look into the example. A agrees to sell his book to B. A is selling. Okay, A is selling, B is buying. Okay, for 100. B promises to pay. Okay, B is telling, okay fine, A, you sell the book for 100 rupees, I will promise to pay you rupees 100 as a consideration. Consideration for A's promise. A is promising, right, to sell his book, so he's agreeing to pay 100 rupees for his particular promise and to sell his book. So A's promise to sell the book is the consideration to B's promise to pay rupees 100. Also, the object of the agreement must be lawful. It should be lawful. It should not be something unlawful. It should not include any harmful elements. It could not include something like bomb or, the elements which are harming the society, or, it should have a very good objective. It should not be it should not be smuggling or anything as such. Here it is a book. Okay, so the object is book, and the object must be of the agreement must be lawful. It must not be illegal. It should not be illegal. It should not be immoral or opposed to public policy, as I told you all. Okay, so A is agreeing to sell, B is agreeing to buy, and both are in consideration. Both are entering into an agreement by fulfilling the promise, okay, of rupees 100. Now, next example, A promises to drop prosecution instituted against B for robbery. Okay, A is promising, okay, fine, I will drop the prosecution. You robbed something, right? You are into a robbery case, but I will drop the prosecution. And B promised to restore the value of things taken. The agreement is void as object is unlawful. Okay, I'm pretty sure you wouldn't have understood this. So there are two parties in a contract, that is A and B. B has robbed something, okay, so A has filed a case against B, and there are legal proceedings that are taken place against B, but B will come and tell A that, okay, fine, whatever amount of goods that I've robbed, whatever the value was, suppose it was 100 rupees or 500 rupees, I will promise you that whatever the amount of goods it was, I will give you the amount of money. I will restore the value of things that I have taken. Okay, suppose 500 worth of product he's stolen. So okay, fine, I will restore the value of goods. So in return, you drop the prosecution. So A will drop the prosecution because B is promising that, okay, fine, I will restore the value of goods for you. But here what happens? The agreement is void because it is unlawful. They are creating an unlawful activity, okay, because what he's done is wrong, but A is only leaving him because he is in an unlawful manner. He is also promising to restore the value. So what they are doing is unlawful and the object is unlawful. So the agreement will not become a valid agreement, it will become a void agreement. So the agreement is not valid. The object is unlawful here, whereas here the object was lawful, wherein in the books that were sold, here the object is unlawful. So if the two essential elements are there, we can say that there is contract which is prima facie, okay, prima facie, which will hold good, or at least we can say that there is an existence of contract. Okay, correct. If lawful consideration is also there and lawful object is also there, if both the elements are present in a contract, we can say that the contract is valid. But if there is one element which is valid, whereas other element which is void, then we cannot say it is a valid contract, right? Both the elements should be valid in order to consider the contract as a valid contract. So we can say that there is existence of contract. Here there is existence of contract, but the elements of valid contract may be wanting. There is a contract which is existing because there is lawful consideration, there is lawful object. But if in a contract there's only lawful consideration and no lawful object, you cannot consider as a valid contract, right? There is a contract, but it is not a valid contract. Okay. Next, it is competent parties. The third element is competent parties. Now you need to have competent parties. The parties to contract must have the capacity or the parties in the contract must have the capacity, legal ability. They should have the ability to make the contract a valid contract. They are entering into contract. Now they should have that capacity to make that particular contract into a valid contract. In every case, there must be assent. Okay, there must be assent. There must be assent of the parties. Okay, now there are parties in an agreement, right? Now these particular parties should take responsibility of making that particular contract which they've entered into a valid contract, right? And also when you're making it as a valid contract, you should take the consent of all the members of the particular party. Okay. Now, if therefore either of the parties to an agreement is deprived of the use of his understanding, or if he is deemed by law not to have attained it, there can be such agreement that shall bind him. Suppose I am in a contract with someone else, okay, and they are not even considering my points. In such a case that I do not have I'm deprived of using my rights, right? So in that way, I can use the understanding which is deemed by law to have attained it. Therefore, such an agreement will bind him. will be certain agreements. Section 11 of the Indian Contract Act specifies that every person is competent to the contract. It is saying that every person in the contract is equally important. Every person's opinion needs to be taken. Okay, now who are the people who are competent to the contract? If first one is the age of majority. He should not be a minor. He should not be less than 18 years. If a person is less than 18 years, his consent will not be taken. He should be a major according to law which he is subject. Okay, he should be a major. Okay, firstly he should be a major. Second one is he should be a person of sound mind. He should not be a mad. He should not be someone who's unstable, who's a lunatic person. He should not be that. He should be a person of sound mind. Firstly is he should be a major. Second is he should be a person of sound mind. Thirdly, he should be a person who is not disqualified from contracting by any law. He should not hold any criminal records. Okay, he should not be disqualified. He should be a person who is qualified by any contract law. Okay, he should not hold any criminal records. Firstly, he should be a major. He should be of sound mind, and he should not be disqualified from contracting. Okay, he should be a person who is qualified. In other words, a minor, a person of unsound mind cannot enter into a contract, and a person who is disqualified from contracting by any law to which he is subject, example, an alien, okay, enemy, or foreign sovereigns, or any person like a terrorist, all of these people cannot enter into the contract. Okay, these people are disqualified. So you should take a person who is not disqualified. Okay, so moving on to the next element, you have free consent. Okay, now what is this free consent? Free consent is also one of the most important elements for a valid contract. Okay, now what is free consent? Free consent, the consent of the parties must be genuine. Okay, whatever the consent of the parties is, all the parties must be it should be very genuine. All the parties must equally agree to the terms and conditions. Everything must be equally done. The term consent. Okay, now what does the term consent? The term consent means parties to a contract. Okay, the term consent, you need to know this. The term consent means parties to a contract must agree upon the same thing in the same sense. Okay, now if there are two parties in a contract, both the parties must agree to the equal terms and conditions. They should agree upon the same thing. If one party is saying no, I want 50,000, and other party is telling no, I want 20,000, this will not work. Okay, both of them have to agree to a similar amount or similar terms and condition. For example, I just gave you the amount. It should be similar terms and condition and everything as such. Okay, now the term consent means parties to a contract must agree upon the same thing in the same sense. That is, there should be consensuad idem. Okay, this is an important term. It is for the term consent, that is equally they should agree. Okay, consent is said not to be free when it is vitiated by coercion, undue influence. Okay, now suppose if a particular party is influenced by the outsider. Okay, if there is any undue influence, if there is any outside influence, then the consent is said not to be free. Okay, if you are agreeing to all the terms and conditions, then it is said to be free consent. But if you are forced to agree upon the terms and conditions, then it is called as undue influence. Due to undue influence, it is called as it is not a free consent. If your decision is influenced, it is not a free consent. Okay, undue influence such as fraud, misrepresentation or mistake. Okay, in such cases contract becomes voidable. Why voidable? As we all know, I've been telling you since the beginning, if one of the element is also not there in a particular contract, that contract will become voidable. It will not be a valid contract. It will become a void contract. It will not be a valid one. Voidable at the option of the party whose consent is not free, because one party's consent is not there, so the contract cannot be a valid contract. For example, now you can look into this particular example. A threatened to shoot B. Okay, now there are two parties, that is A and B. Now A is threatening B, okay? He's telling, he is trying to, he will tell, he is threatening B that he will shoot him. Now, if B does not lend him rupees 2000 and B does not lend him 2000, okay? And B agreed to it. Here, agreement is entered under coercion and hence is voidable. Now, B is getting scared. B did not lend A 2000. That is why he's threatening him that he will shoot him. So it is not a valid contract. It is undue influence. It is a fraud. Okay, it is fraud. It is, you are threatening them. It is illegal. That is why the contract is not valid. It is void. Next, the next element is the agreement not expressly declared void. Now this agreement is not expressly declared void. Okay, now we'll see what is there in this. The agreement must not be one which the law declares to be either illegal or void. Okay, there should be an agreement which the law is not declaring whether it is illegal or it is void. A void agreement is one which is without any legal effects. Okay, illegal agreement is an agreement expressly or impliedly prohibited by law. Now the agreement not expressly declared void is basically, again, one of the element is missing, then it will not be declared as a valid agreement, and also it will contain any illegal activities because of which it is declared void. Okay, you're not expressly declaring it, but it is declared void. Now, for example, agreements in restraint of trade, marriage, legal proceeding, etc. are void agreements. Those agreements are prohibited by Indian Penal Code. Example, threats to commit murder. Okay, as we looked into the free consent also, here they will continuously threat. Okay, that is, you will threat them to commit murder, publishing wrong statements, defamatory is wrong statements, or agreements which are opposed to by public policy or are illegal in nature. Okay, all these elements, when they are in a particular contract, that particular contract is not valid, it is a void contract. Okay, I hope this point is clear to you all. Next, you have the sixth element, that is certainty of meaning. Now, what is the certainty of meaning? Certainty of meaning is the agreement must be certain. It should not be vague or indefinite. Now, any agreement that you are entering into, you should be able to give a meaning to that particular agreement. Like suppose you have a particular business, like suppose it could be anything, it could be garments or anything. There should be a meaning to it. Okay, it should not be vague. You cannot just simply randomly enter into any agreement or all of that. So the agreement which you are entering, it should not be vague. It should have certain meaning to it. Okay, it should be certain, it should be very certain, and it should have meaning. It should not be vague. For example, A agrees to sell B 100 tons of oil. Okay, so there is an oil business which is happening between A and B. A is selling and B is buying. There is nothing certain in order to show what kind of oil was intended. It could be coconut oil, it could be it could be coconut oil, it could be cooking oil, or it could be petrol oil, kerosene, or whatever it is. They are not telling which oil that is. Okay, so you should be specific. You should specify that I will sell coconut oil to you. Only in that case your agreement will have certain meaning. If you're not specifying which oil it is, then your agreement will not have meaning. Okay, so meaning is very important, and you should specify in oil also which oil are you giving. If you just tell randomly, then it does not hold any meaning. And hence, if it is like this, again the element if this element is missing, then the contract will not be valid. Next one is possibility of performance of an agreement. The terms of agreement should be capable of performance. Now, whichever your agreement you are entering, it should not be for the sake of just entering into the agreement. That agreement should be you should be able to perform, you should be able to achieve the objective. Okay, the terms of agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. An agreement, suppose it does not have a meaning, and suppose that agreement cannot be done in real basis, like suppose it is some agreement, it could be for example, I am selling pencils. This is something which can be done, right? It is not something which is impossible. Suppose I tell them I will smuggle gold and all of this. This is something which is possible but also impossible, and it cannot be done. It is done in an illegal way. So you should have possibility of performance. It should you should not enter into agreements which are not at all possible. The agreement should be possible. Now, when you look into this example, you will be able to understand. Example, A agrees with B to discover treasure by magic. Okay, you are this is a this is completely, they are discovering treasure with the help of magic. The agreement cannot be enforced. Why? Because we all know magic is something that, it's just not existing. Okay, you are discovering treasure which through magic. Okay, it is something that cannot be implemented. The agreement cannot be forced because it is not able to be performed. You cannot perform it, you cannot discover the treasure. So the element is so the contract is not a valid one. Next, let's move on to the next element, compliance of necessary legal formalities. Now, legal formalities, what is a contract? Contract will only become a valid contract when you have necessary rules and regulations. Okay, and when you are actually for abiding by the rules and regulations. For example, your college also, you need to wear ID card and all of this, right? You need to comply with the rules and regulations wherever a particular. Now, under compliance of necessary legal formalities, your contract should comply with all the necessary legal formalities. Wherever a particular type of contract requires by law to be in writing and registered. See, when you usually enter into a contract, there will be a one party, that is A, and one party there will be, or there could be another party C, and multiple parties. Okay, now these two parties, when there are, suppose we are taking only two parties. Okay, now when two parties are entering into a contract, the contract must be in a written form. Okay, it should be written and it should be documented. The contract should always be written and documented. Now, why should it be written and documented? Because it is human nature to usually forget things. Suppose all the rules and regulations are discussed, all the amount is discussed. Okay, few people might tend to forget it. So when everything is written and documented, there are no chances of forgetting. Everything will be decided and everything will be in a proof format. Okay, you will have proof for everything. There will be no chance of forgetting. Okay, you will not be able to forget it. Okay, no chance, no forgetting. Okay, so when things are not written, registered and documented, you will have chances of forgetting, and when it is not registered, it can be misused. That is why you need to comply with the legal formalities. Okay, when a particular type of contracts that is required by law in writing and registered, it must comply with necessary formalities, like how it should be written, how it should be attested. If you see your property papers, how the property paper is written, how it is attested, how the seal is there, how it is registered. Otherwise, which is unenforceable. Okay, it should be according to the rules and regulations, how it should be written, attested, registration. If it is not according to the rules and regulation, then again that contract will not be a valid one. Okay, for example, now please look into the example where it requires an agreement to make a gift for natural love and affection. There must be in writing and registered to be valid. Okay, now suppose for example there are two people, that is A and B, and they are very close to each other. Now A decides to give 50,000 rupees to B. Okay, but then he is not written and registered, so there will be no proof regarding it, and that will not be valid. Whereas if you are writing it, you're documenting it, you're registering it, then it will be valid. You will also have proof, and then money will be received. Okay, now next, let's move on to the next topic. So now let's move on to the next topic, that is types of contract or the classification of contract. Now there are different types of contract. They may be classified as follows. Types of contract on the basis of, okay, on the basis of validity, first one. Second one is formation and performation. First one is you're checking your validity. Secondly, you're checking the formation. And third one, it is classified on basis of performation, how it is performed. Under your validity, you have sub points. That is, you have valid contract, you have void contract, you have voidable, illegal agreement, and unenforceable agreement. Okay, under your formation, you have express contract, implied contract, quasi contract. Under performation, you have executed, you have executory contract, you have unilateral, and you have bilateral contract. Now on the basis of validity, what is the first type of contract on the basis of classification? It is validity. So on the basis of validity, first one is your valid contract. Now what is a valid contract? As we studied earlier, looking into the elements, we looked into the 8 elements, right? Only if the 8 elements are there, that particular contract will be a valid contract, or else it will become a void one, right? So now what is a valid contract? So under your So under your valid contract, it is basically an agreement which is binding. Okay, it is an agreement. Now what is a contract? Again, it is an agreement which is binding. You need to remember, it is binding and it is enforceable. Is a valid contract. It contains of all the essential elements of valid contract. Now whatever elements we studied, 8 elements, the 8 elements, it should comply with all the 8 elements. Only if all the elements, 8 elements are present, only that particular contract will be called as a valid contract. Now next one is what is a void contract. Now suppose for example, if all the 8 elements are not present in a particular valid contract, that contract will be called as a void contract. It is a contract without any legal effect and cannot be enforced. Okay, this particular contract will not be enforced by the court of law. It cannot be performed. It cannot be coming into existence as per the court of law. Okay, section 2 subsection J, you need to remember this. Under void contract, it defines void contract. Section 2 subsection J defines void contract as a contract which is ceased to be enforceable by law, becomes void when it is ceases to be enforceable. Okay, when the court of law cannot perform it, it ceases to be enforceable. Okay, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Okay, I hope it's clear. For example, A contracts with B. A and B are entering into an agreement. Now A is contracting with B. B is what? B is the owner of the factory. Now B is the owner of factory, and B is telling A that he will supply 10 tons of sugar, but before the supply is effected, the fire caught in the factory and everything was destroyed. Here the contract becomes void. A and B are in contract, okay, but B is telling, okay fine, I will supply 10 tons of sugar, but before B actually supplies the 10 tons of sugar, there was a fire which was caught in the factory. Now how will B supply the... Now before B actually delivers the goods to A, that is 10 tons of sugar, the factory of B has caught fire and all the product is affected, all the sugar is destroyed. So here the contract cannot be brought into force. So hence this particular contract will become a void contract, because this contract cannot be performed further because all the items are destroyed. Now next is voidable contract. What is voidable contract? As per section 2 subsection I, it is an agreement which is enforceable by law at option of one or more parties, but not at the option of others, is a voidable contract. Okay, here what it is telling is basically, according to section 2 subsection 1, a voidable contract is basically an agreement. Okay, it is an agreement which is enforceable by law. Now when is this enforceable by law? At the option of one or more parties. We all know there are parties in an agreement, that is one or more parties. Okay, it will only be enforceable by law when there is option of one or more parties, only the parties in the agreement, but not at the option of others. That is someone external who is coming and influencing the parties. Only if this is happening, then it is not a contract which will be valid. It will become a voidable contract. Like as we studied earlier, like misrepresentation, fraud activities, someone misinfluencing. If someone is influencing your decision, if there is fraud, if they are threatening you, then it will become a voidable contract. So moving on to the next, you have an example for the same, that is voidable contract. A contract brought about as a result of coercion, that is undue influence. Coercion is nothing but undue influence. Okay, as I told you all, if someone is influencing your if there are two parties in an agreement, that is A and now B, if these two parties are mutually agreeing to the terms and conditions, if they are properly following the rules and regulations, then that particular contract will be valid. Now if suppose C is an outsider and he's coming and influencing A and B, or he's coming and influencing only B, in that way the contract will not be valid. Okay, because that is undue influence and it will become a voidable contract because it is fraud, misrepresentation, so it will become voidable because here there was no because A and B are not mutually agreeing to the terms and conditions. B is getting influenced by C. Suppose A will agree to give 20,000, okay? For example, A will agree to enter into an agreement for 20,000. Now even B might agree for the same amount. C might tell A, no, that amount is very less, you ask for 40,000. Okay, so this is undue influence. Now B is getting influenced by C, because here there is undue influence, misrepresentation, because of which it will become a voidable contract. Now void and voidable contract, this is a difference between void and voidable. What is the basis of difference? It is definition. Void contract is a contract that ceases to be enforceable by law. The court of law is ceasing it to be enforceable. Voidable is contract is enforceable at the option of aggrieved party. Here, if both the parties are mutually agreeing, then the contract is enforceable. If not, the contract is not enforceable. Next, nature. Contract becomes void either because of sudden and unexpected events or of law changes before the performance. Example, we told the sugar factory, okay, the sugar which got burnt. Okay, this is the nature of void contract. Under voidable, contract becomes voidable when it is caused by coercion. As I told you all, someone will come and influence. Example, undue influence. Okay. Next, rights. Under void contract, it does not provide any legal remedies for the parties to the contract. Okay, no legal remedy is provided to the parties who are in the contract. Here, an aggrieved, under voidable, the aggrieved gets a right to rescind the contract and to declare it void, otherwise it remains valid. Okay, if the aggrieved party is not clearly telling as to who is influencing him or what is happening, until then the contract will remain valid only. There is nothing like void in that. Okay, so moving on to the next type, it is illegal contract. Now what is an illegal contract? Illegal contract, the term only states that something is not right, it is something against the society, right? So it is a contract which the law forbids to make. Okay, here the law is forbids to be made. The law is forbidding it to be made. The court will not enforce such law, such as contract, but also connected contracts. Okay, this particular type of contract will not be accepted by the court of law, and also similar kind of contracts which are connected with this, even those particular contracts will not be accepted by law. And illegal agreements are void, but all void agreements or contracts are not necessarily illegal. Suppose, for example, C. Now suppose one or more agreements will become void. When will they become void? If they are not complying with all the elements, all the 8 elements which we studied earlier. Suppose even one element is also missing, then that particular contract will not be a valid one. Now, not necessary that particular contract is illegal, right? So that is what it says. Now all the illegal agreements might be void, but not necessarily they are illegal. Okay, they can be void, but not necessarily they are illegal. For example, contract to commit crime, or it could be terrorist, or it could be anything. Okay, it could be smuggling, it could be anything. These are the few examples of illegal activities. Contract that is immoral, it is against the society, it is against the rules and regulations, against the values, okay, which is opposing to the public policy, are illegal in nature. Similarly, R agrees with S to purchase brown sugar, an illegal agreement. Suppose if R and S are buying and selling brown sugar and it is against the rules and regulations, something, it is fraud, okay, it is something related to drugs and all of that, then it will become an illegal agreement. So now, according to section 2 subsection G of the Indian Contract Act, an agreement not enforceable by law is void. Okay, agreement which is not enforceable by law is void. Now we all know by now what is a void contract, what is a voidable contract, what is a valid contract also. And in case if a particular contract does not consist of all the elements, it will be considered as void, but it is not necessary that it is illegal. Okay. Now next, let's look into what is void and illegal agreements. We looked into void and voidable. Now let's look into void and illegal agreements. So what is the basis of difference? Void agreement, illegal agreement. Scope. Scope a void agreement, as I told you all, it is not necessary that it should be illegal. It could also be a void agreement because one of the more elements is missing. Next, illegal is basically it is an agreement which is always void. Okay, illegal agreement is always void. Okay, always is always void. Next, nature of punishment, not forbidden under law. Parties are not liable for any punishment. Under void agreement, parties are not liable for any punishment. Okay, because it is not necessary that particular thing is illegal. It can also be because one of the element is missing. Here they are liable for punishment because it is clearly shown that they are into any fraudulent activities or any terrorist activities or any smuggling activities or anything, because it is illegal. Next is collateral agreement. It is not necessary that agreements collateral to void agreements may also be void. It may also be valid. Suppose there is one agreement relating to this. Suppose there are two agreements, okay, A and B. One agreement might have one element missing, whereas other element which is collateral might have all the elements which are present. So not necessary because A is void, B should also be void. If A is void, B can be valid also. Okay. Now, under illegal agreements, agreements collateral to illegal agreements are always void. Okay, here it is A and B, right? If A is void, B is not necessary that it should be void. If A has one element missing, it is void. If B has all elements missing, all elements present, it is valid, even if it is collateral. But here, if A and B are collateral, if one is illegal, the second also will be illegal only. It will always be void. Next one is effects. Under effects, under void agreement is not voidable, void ab initio, but may subsequently be void. Okay, void agreement is not void, but may subsequently be void. It is not always void, but it can subsequently become void. It can become void because of the elements that are missing. Here, under illegal agreement, all illegal agreements are void from the beginning. Okay, as we looked into all the points, if you look into all the points carefully, you will clearly understand as to why an illegal agreement, the term only states that it is not right. Since the beginning, it is wrong. It is illegal from the beginning. So the last point under your valid contract is So the last point under validity is unenforceable contract. Now, what is an unenforceable contract? Unenforceable contract is where a contract is good in substance, but because of some technical defect, that is absence in writing, barred by limitation, etc., one or both parties cannot sue upon it. It is described as an unenforceable contract. As I told you all, once you enter into a particular contract, you need to write down all the terms and conditions, all the rules and regulations, everything. So even if you have a good substance, but if you have some technical defect or if there is some limitation, that particular contract will become a contract which is unenforceable. Okay, you cannot enforce it. It will become unenforceable. You cannot perform that particular contract. So this is under these are the 5 points under validity. I hope it's all very clear. In the next video, you will be studying on the basis of formation of the contract.